of digital rights in Africa. My name is Ikechukwu Uzoma, and I'm the staff attorney at Robert F. Kennedy Human Rights. I'm honored to facilitate today's conversation. The panel is holding on the sideline of this year's Forum on Internet Freedom in Africa, FIFA 2022, and it's organized by CIPESA. We are grateful to CIPESA for creating this platform to have this very important conversation. This panel in particular is co-organized by the International Justice Clinic at UCI Law, Unwanted Witness, Uganda, and the Robert F. Kennedy Human Rights Organization. And we are grateful to all the partners for their collaboration in putting this together. Let me also extend a note of gratitude to all our participants for finding the time to join us today. We really do look forward to a robust and fruitful conversation, and we welcome you all to use the Q&A function and use the chat function to share your questions and share your comments. We'll be happy. We've reserved sufficient time at the end of the conversation to have everyone share their thoughts and contribute to today's conversation. You could also enable the live transcripts at the base of your screen if you would like to receive the text of the conversation as it proceeds. Please permit me to begin now with some framing comments as we commence this conversation. Strategic litigation, as we all know, is an important tool for the protection of human rights broadly and has been very useful for the defense of digital rights across the world, including in Africa. As in other parts of the world, Africa has faced significant challenges and threats to digital rights. Access to internet and internet platforms have come under serious attack. Internet shutdowns, bandwidth throttling, platform access restrictions, internet and social media taxes, and the failure to uphold or defend net neutrality are examples of some of the challenges and threats to digital rights that we have experienced on the continent. In the last decade also, there's been a flurry of repressive legislations that have been used or attempted to be used to stifle online expression, association, and assembly. Colonial era defamation laws, as well as new iterations and other laws purporting to address issues such as cybercrime, hate speech, disinformation, fake news, continue to be passed or proposed by governments. We've also experienced a new trend of regimes and laws mandating SIM card registrations, enrollment into digital ID programs with limited protections for privacy and limited data protection provisions. In addition, illegal surveillance through CCTV deployment in public places, facial recognition technology, and in the use of malware to target journalists, activists, and political opposition continues to reoccur. And even more seriously, since this is a conversation about strategic litigation, we've also seen strategic litigation against public participation, popularly called SLAPs, used against journalists, against human rights defenders, and other actors in a way to stifle free speech and to limit civic participation in governance. We do understand and we reckon the work that most of our speakers and other organizations have done in identifying these challenges and even challenging these threats to digital rights through domestic courts and through regional and sub-regional mechanisms. Today's conversation focuses on the next steps, on the future, the next steps for strategic litigation for the protection of digital rights. we are aware of these challenges and the successes that have also been recorded in responding to these threats through litigation. There are a lot of cases and a lot of positive jurisprudence that has been the result of strategic litigation that has been led by civil society and journalists and the like in furthering strategic litigation and in furthering digital rights and protecting digital rights in Africa. The question now is where do we go from here in noticing the use of this repressive tactics in limiting digital rights? How else can we use strategic litigation to consolidate and in a sense strengthen existing jurisprudence, identify and fill gaps, jurisprudential gaps that do not exist, build communities of practice that support strategic litigation, and even the implementation of this decisions from from strategic litigation, identify allies in government that help in the implementation of decisions. These are some of the conversations that we'll be having today. And the hope is that this is one of many conversations that we'll continue to have, both on the auspices of FIFA, but also beyond that, going forward in building out the work that we are all doing around strategic litigation. To take this conversation further and to reflect on on some of these questions that have been raised, we have an esteemed panel that would begin in a bit to address some of these questions. And our first speaker today is Dorothy Mukasa, who is the team lead at Unwanted Witness. We would share a full bio of Dorothy in the chat, but I would welcome Dorothy now to speak to us about the great work that Unwanted Witness is doing in Uganda and beyond, and reflections on what the future holds for strategic litigation. The floor is yours now, Dorothy.
Thank you so much, for greetings at Unwanted Witness, we believe in the power and the value that comes with strategic litigation. And I want to echo that systematic litigation really is one of the means can change systemic human rights abuses in our world. Digital rights is one of those abuses that abuse that you mentioned in your opening remarks.
I'm so sorry. So sorry, Dorothy. It seems your audio is cutting out a bit. So maybe if you could hold the mic closer to your mouth, it may be clearer.
Okay, let me try that. Is it fine now? Can you hear me properly?
Yeah, it's better now. It's better now. And please, participants, please let us know if you can't hear clearly, and we'll try to make it work. Please proceed.
Okay, thank you. Like I was saying, strategic litigation has contributed to meaningful evolution of legal frameworks that truly ensure the protection and respect, as well as promotion of human rights. Strategic litigation has been really used in defending human rights and freedoms of expression on the continent. We've seen different regional and sub-regional courts in Africa really addressing issues of abuses of digital rights and giving really judgments that are really shaping jurisprudence in the region. I'll give an example of the 2019 of the East African Court of Justice that handed down a judgment which declared that Tanzania's Media Service Act, null and void. This is a law that has been used in Tanzania to criminalize free media. But also know that traditional laws and colonial laws continue to be used to criminalize digital rights in Africa. Laws like that permit sedition. One of the laws in Gambia was really also judged against by the ECOWAS court. These are progressive judgments that really enable the enjoyment of digital rights. Now the question around maybe we can ask is whether these judgments are really enforced in these countries. That's another area of discussion, whether really if we have these beautiful judgments that are being made by regional courts, what happens to country to governments that when it comes to implementation and enforcement of these judgments. The enforcement is really still low, and adoption of the judgments in the respective countries, and also this waters down the efforts of the different courts that are really pushing for the enjoyment of digital rights in the region. And therefore this calls for collaboration, not only amongst civil society, but also like-minded agencies. It could be government. We're seeing individuals within government really championing different African states, championing the right to the digital rights per se. And these are groups that civil society can really capitalize on to be able to push implementation of these judgments. But also collaboration with regional bodies, is really very, very important. Special rapporteurs, for us working with these groups is important. But also when it comes to litigation itself, we are seeing different civil society groups, taking on litigation without the support of regional organizations and civil society groups. So it's important that we build a strong collaboration base when it comes to strategic litigation, because we all know that strategic litigation, first of all, is protracted. It's really very, very long. It can be it can exhaust a single organization, but it's also costly. There's a lot of money that is required for a single entity to be able to litigate, in Africa, and also both at regional and national level. We have cases, for instance, at unwanted witness that have dragged on for as long as 5 years now, cases that we've taken to domestic courts, like the Computer Misuse Act that we are challenging. This particular case has been in court for over 5 years, but government continues really to clamp down on free speech online, continues to arrest and detain journalists, defenders, opposition, politicians, using the same law. And recently there was an amendment making it really more stringent and targeting to specific groups that have traditionally suffered the long arm of government. So we need to have strong collaboration as actors, and also extend a hand to different institutions, and agencies that are working towards promoting digital rights, not only working as civil society. Universities, researchers are very, very critical when it comes to defense of digital rights. For example, if we are working towards strategic litigation, we need research, and universities can be good allies. We need expert opinions, special rapporteurs and individuals working at different levels in different regional and international mechanisms can be very, very supportive. in terms of providing expert opinion. We need advocacy, advocacy. We need the media. We need our allies within civil society. We also need to extend our cause to groups that are not working on per se on digital rights. For instance, I'll give you an example. We are today in Uganda taking on government for excluding older persons from accessing social protection grants, simply because they do not have an ID. So as Unwanted Witness, a digital rights organization, we are working with another organization that is, focusing on social and economic rights. So we need such collaborations for us not to be seen as antagonists, but also because digital rights issues, really affect, extend to other rights. So we need to interest those other groups to be part of our cause, and that makes our cause even more stronger and accepted by the citizens, because at the end of the day we are litigating on part of the citizens. What do we need to do? There's so many issues, I think, that continue even when the already judgments that we are really proud of as digital rights activists. We do realize that more laws, more actions, more violations continue towards digital rights. So we need to identify those repeatedly violations that we can take on. For instance, internet shutdown. There's been litigation around internet shutdown, but it hasn't stopped. It continues. Uganda, wherever there is an election, internet shutdown occurs. We are in court in Uganda domestically, but we need to go from beyond Uganda and take the regional aspect. Perhaps that we could get speedy and more fair judgment that can form, that can help change the legal frameworks. But we also need to look at digital taxation. This is a trend that is really expounding and scaling out in Africa, where there's a tax that is slapped on the enjoyment of digital rights. Illegal surveillance is one of the areas that is very, very common and now in Africa. We are seeing different governments, partnering with private companies, to really get that technology that can give it more power to really surveil on its citizens. So we need to look at the private and public partnerships in surveillance that is really growing, and we know that there's really a rush for these companies to come to Africa and sell these technologies, cheap technologies, and test their technologies in the region. So we need to look at these areas that are really continuously growing, but also have been around for a long time and continue to affect the enjoyment of digital rights in Africa. Thank you. I think my 2 minutes are done. Thank you so much.
Yeah, thank you so much, Dorothy, for the great work you do and for your intervention. It's clear, that just like we said at the outset, there are a variety of these challenges that exist, and we need to also come at it from a variety of approaches, including, I love the fact that you highlighted the issue of intersectoral and cross sectoral collaboration in terms of advocating for changes that are necessary to ensure the protection of digital rights, and in addition to equally go the long haul of strategic litigation. You made a clear point that it takes a long time to see litigation through, and when it's done in collaboration, it's more effective, because when maybe one party is weak, the collaborating party supports, in holding on and following through with the litigation. You also made a great point around enforcement. And I think in the context of strategic litigation, it's important to think about enforcement and implementation even from the outset of the litigation, including with respect to just, you also mentioned that there are some members of parliament who are championing positive legislation or legislation to protect digital rights, and it will be great to carry them along in thinking of strategic litigation. I'll come back to you later around the issue of illegal surveillance and the use, the private and public partnership that you spoke about, especially when these companies are not also located in Africa. There are foreign companies selling some of these technologies. How do we think that strategic litigation can help to ensure that those companies also are held accountable for the abuse of this technology in terms of surveillance? So thank you so much for those comments, and we'll get back to you with some questions. Let me also encourage our participants to send questions if you have them through the Q&A function or through the chat function, and we'll make sure to get to them soon. Our next speaker is Tobikile Matimbe, who is the who works with Paradigm Initiative and has collaborated, has worked on a number of litigation before domestic and regional mechanisms around digital rights, and has also collaborated specifically around the Twitter ban case in Nigeria. We'll share a full bio in the chats to everyone, but it's a pleasure to have you, Tobikile. Thank you so much for making the time to be here. I know you've been on many panels today already. Thank you so much. The floor is yours.
Thank you so much. I was hoping you didn't notice I was on a lot of panels, but I'm raring to go on this one. Thank you so much. And my name is Tobikile, as was already mentioned, and I work for Paradigm Initiative as Partnerships and Engagements Manager. With regards to this conversation on strategic litigation and the key question, what next? I will start from a position of talking about, the gains that have been there over the years, for digital rights. So looking at, for instance, the Konate case, which has elaborated on how criminal defamation laws tend to violate human rights. And, that case, the Konate case, was progressive. And I think the African court was able to pronounce clearly that, false news or defamation rather, should not be subjected to criminal sanctions. But we see that across, the continent, we see a lot of, media practitioners bearing the brunt the most of, crackdowns from governments and criminal sanctions for their actions. And at regional level, the African Commission has come up with a declaration of principles on freedom of expression and access to information, and has buttressed the fact that, what should be a priority for states is civil sanctions as opposed to coming up with criminal sanctions, and should be able to repeal these laws, etc. So you find that at regional level, with the Declaration of Principles on Freedom of Expression, it has kind of like laid the foundation for which, lawyers across the continent can have a basis to challenge, criminal defamation. I think now, because mostly people engage online, even fake news or false news provisions, they're targeting online, dissemination of information, or targeting whatever activity happens online. You find that we can definitely draw insights from, the declaration, as well as strengthen our cases from, already existing jurisprudence, and looking at cases like Konate for backing up our cases. So I think as lawyers as well, we need to be in a space where we are, collaborating, even if we are not really working in NGOs or civil society organizations, or maybe we are just within our law firms. There's room for, looking broadly to see, okay, how can we collaborate in terms of, bringing these cases before the courts? And one benefit of that is that while we are litigating and pushing forward our cases within the different courts, there is another, arm of force, which is an advocacy force, which can come with the, with our partners that we collaborate with to move, for speedy outcomes to our cases. So you'd find that, for instance, if you're litigating on a case in an internet shutdown, on the other hand, you have a whole mass of, coalition action or organizations that are calling out for an end to internet shutdown. So you find that that mass itself, is an advocacy mass, but, coupling that with strategic litigation, efforts definitely leads to successes, or, in the long run, it gains mileage. And even if in a case, we do not win or get the relevant outcome that we want out of the case, definitely what we win is, awareness around that case, awareness of the issues, and awareness of what digital rights are. So it is definitely something that I would highlight as critical to our next steps in regards to litigation. And also you find that, we are operating in a context where, digital rights issues are sort of like new to, a number of actors, including judiciaries in our different countries. So you find that, we can also make efforts towards securing our cases, so securing the wins that we want to see by engaging with the judiciary and making sure we raise the capacity. And we can only do that even as legal practitioners by linking up with the relevant organizations that are doing their work, that are doing the work of raising awareness, or rather capacity building on digital rights issues. So for us as Paradigm Initiative, of course, we've been involved in a number of cases, and well, of particular interest is the Twitter ban case. And I will say for a fact that, we were able to leverage on, having, the ECOWAS court available to be able to determine what the issues were and make a pronouncement on, on the Twitter ban. And while it took time, for, the Twitter ban lasted as far as 7 months. But to be honest, I think the journey of litigation is not, an instant journey, but, across, the world really, and across the, the range of cases that are presented before courts, some cases are speedily determined and some cases take long. But if you see that particular case, you find that there was a lot of action, collaborative action from partners, especially under the Keep It On Coalition, pushing for, for the issues that were, raised in the case, for an end to that Twitter ban. And apart from that, there was an ongoing process with other partners as well. We collaborated with partners like SERAP to be able to put forward, these cases before the ECOWAS court. But before I conclude, I have to say that it is only for the privileged that have access to certain sub-regional, platforms or regional, sub-regional tribunals or courts that can be able to determine cases. If you are to look at the whole continent from a bird's eye view, you'll see that in Southern Africa, there's nothing much we can talk about with regards to sub-regional platforms, because we have our SADC tribunal, which was disbanded. So what we have is we simply stop and we emulate and we smile, because I'm from Zimbabwe and I'm from Southern Africa, and we're like, wow, okay, those who have issues arising on digital rights cases within the context of Nigeria or within, the West African region, they will file their cases before ECOWAS. We do not have an ECOWAS to file these cases before. And for those who are in East Africa, they will also have the East African court that they can present their issues. And we've seen a lot of traction as well within ECOWAS court with determining cases. And the question then would be, what next as well for strategic litigation for countries in Southern Africa? And while we have the African court as a regional court that is available, it's not everyone, that is, able to actually, push forward their cases through that court, because for obvious reasons that, of course, we need more, right? We need other countries as well to, be part of that African court protocol. And not just that, we need them to be able to sign a declaration that allows individuals and non-governmental organizations to be able to actually bring cases before the African court. So for instance, my case in Zimbabwe, if there are issues and we've exhausted all local remedies, we cannot take any case before the African court as individuals or non-governmental organizations, because we are barred to do that. So what next for strategic litigation? We need to be able to, look at it as something that is part of the process. So how can we get ourselves access to platforms so that we strategically litigate? There is no strategic litigation when we do not have access to certain platforms because of these barriers that I've highlighted. Some have to do with obviously the ratification processes of states, but also at national level, how, how proactive are we to change policy, to change the landscape, the jurisprudence in our countries? How actively are we involved in that process? What does this look like? It looks like this. We need to be able to see the gaps in terms of the cases that we've, the wins that we have, and deliberately look around, monitor the space and see where there are violations and take up those cases so that we are able to get judgments. In 2019 in Zimbabwe, we had an internet shutdown as an example, and Zimbabwe Lawyers for Human Rights, MISA, put forward these cases because this case before, our High Court. And yes, we got a win in the sense that the High Court pronounced that this was, in fact, it did not rule on the constitutionality of it or the violation of fundamental rights and freedoms, but ruled on a procedural aspect that, there was a problem there in terms of the procedure. The minister that had authorized this internet shutdown was not the right one. And it was a win in the sense that, of course, our victims, the harm that was going on stopped, and there was certain pronouncements made by the High Court. But in terms of actually pronouncing this as a constitutional violation, we still did not get or strike that note. So we still need to present cases so that at some point we get to develop the law in that in that regards and shape policy. So yes, we can leverage on platforms, but we also need to have access. So there's room for us to work towards that and team up with civil society organizations to actually drive campaigns even for ratification of certain protocols that allow certain countries to also enjoy that benefit. Otherwise, for some countries, well, we don't have anywhere to take this. We cannot take our cases in Southern Africa to the ECOWAS Court, which is doing brilliantly in terms of addressing some of the issues. Thank you.
Thank you so much, Bikile. You raise a lot of points that I would love to, come back to. Especially the last one around just the impact of regional and sub-regional mechanisms in advancing strategic litigation around these issues, because it does seem like in places where we have this mechanism, they're doing great. But in places where these mechanisms do not exist, or at least there's no access to the ones that exist, we see sometimes that domestic courts, for example, the Constitutional Court in South Africa, steps up sometimes, to also deliver some positive decisions around some digital rights issues. And we see that civil society is making do with what exists. But you make a strong point about the fact that strategic litigation would only happen in terms of the regional and sub-regional mechanisms where there's access. And so if the focus of, especially the lawyers is just the litigation, and the advocacy around and support for the mechanisms is not also taken as part of strategic litigation, then we are shooting ourselves in the foot, which is a reflection that I'd like us to come back to. But I also appreciate the fact that you mentioned capacity building in terms of identifying actually the wins that we have. There's been a lot of positive jurisprudence around digital rights, but they may not be all together in one book or all together in one source. So how do we ensure that as students, as lawyers are being graduated from the law schools, that they are also getting the awareness of these jurisprudence? How do we share jurisprudence between Africa and Latin America, for example? How do we ensure that everyone gets a fair sense of what exists, and so that in planning future litigation, we are not, in a sense, reinventing the wheel. We are taking it a step further, which speaks to collaboration and the like. So I would really thank you for those thoughts, and would be back with some questions. We got some comments on the chat function, saying that the chat function is disabled. We apologize for that, and we ask that if you have any comments, whether questions or just comments, please feel free to use the Q&A function, and we'll make sure to reflect your thoughts as the conversation progresses. Thanks, and please bear with us. We will now move over to our next speaker. Again, in an effort to ensure that we have that cross-regional sense of what's going on in terms of strategic litigation and how we take it further, and to engender some exchange in terms of best practices. We have a fantastic advocate and speaker in Fernando Garcia, who is the executive director and co-founder of R3D, a digital rights organization based in Mexico. We'll share a short bio in the chat, but it's my pleasure to welcome you, Luis. The floor is yours.
Thank you very much. It's an honor for me to be in this space and to be able to talk with you about this issue that's I'm very passionate about, which is strategic litigation. And I mean, strategic litigation on digital rights faces and has faced many unique challenges that we need to address. So I will just throw a few ideas about things that I believe work or are useful, things that we have learned that are things that we need to take into account. And some, I apologize in advance, might be a bit obvious, but I don't want to let things unsaid because it's never obvious for everyone, and it's important for us to build common knowledge and a common understanding around these issues. And the first thing that I would say is that we need to accept the specific challenges that strategic litigation in digital rights has. And one is the complexity, sometimes technical complexity of the issues that scare judges. It's just things that they are just not used to, they don't understand. Even when they're not that complicated, just the fact that there's the word of technology or a certain technology is mentioned in a lawsuit, it just scares them and they feel they don't know what they're doing and they don't want to be embarrassed, and they tend to do what they know, and it's not something that's a good environment for being successful in strategic litigation. And there's a few ways in which we try to address this problem. One is that we've been doing litigation in Mexico and internationally for many years, and we've been aware that we cannot just throw a whole plate of food in the face of the judge. We need to give them bits of the food so they can eat the whole plate. So it's okay, and it's important to map which bits are more easy for the judges to swallow and which ones we need to build towards that. And we've been trying to do that. I will give specific examples. I will give specific examples throughout my presentation. But this is something that is really important, to be able to have building blocks from which you build the next and the next and the next cases and the next opportunities. And you kind of like handhold the judiciary towards the standards that we want to get established through jurisprudence. Another thing that it's important to be successful, I think, in strategic litigation efforts that increasingly involve complex technologies. Let's say, for example, automated or artificial intelligence or machine learning or automated decision making that can produce discrimination or can produce other human rights harms. We definitely rely on it. It's difficult. It's normal that judges don't trust us. Like, who are you? Who are you to tell me that this technology discriminates? Or and most of the time, who is appearing before a judge is a lawyer, and there's suspicion about what are your credentials about knowing how these technologies work, no? And definitely there, you rely on expert opinions, on literature, to be able to support the claims and the more scientific claims that are the basis of your lawsuits, for example. I'm thinking, for example, we're doing that in litigating against facial recognition surveillance in public space, for example. And there's a lot, and I think the main word that I want to get across is collaboration. There's a lot of collaboration that it's needed for litigation to be successful. I believe it's a fantasy, a compelling and a fantasy that I empathize with, that you are a lawyer and you alone make this case that solves this issue. And the truth is that it's very unlikely that will happen, that you will need other blocks, other organizations, scientists, other types of collaboration to be able to be successful. And one of those types of collaboration that I think is been important and we are trying to enhance is sharing expert opinions or sharing translated literature, because sometimes, most of the time, the science or the expert opinions or the expert literature, it's in our case in English, and we need to translate it to Spanish, and that costs money. And if I already did it, I already have an official translation in Spanish of this document, of this expert opinion, I can share that with another organization, with another lawyer, and make sure that we have more cases, better cases at the same time. Obviously, there's other challenges like the length that these lawsuits take, particularly when we're using regional or international human rights bodies. And this is something that we need to just live with and accept that we are doing things today that will be maybe decided by regional institutions 10 years later. No? And this is something that we have been doing. We've been for 8 years doing litigation on a case that it's going through the Inter-American System of Human Rights, that we expected to eventually reach the Inter-American Court of Human Rights, and that we know that the issue that we were raising there then might be a little bit outdated because of the technology that has changed. But still, I think we need to make regional courts aware that they need to seize these opportunities to establish standards that apply not only for the specific case that is brought for them, but that allows other courts, national courts, other lawyers, etc., to build upon and to use. A little bit of the like what I was saying about the building blocks, and that's something that we've been doing. For example, trying to build standards related to transparency or to controls regarding targeted surveillance by intelligence agencies or law enforcement, but that now we're using those building blocks to try to oppose other types of surveillance, such as mass surveillance, surveillance such as facial recognition surveillance in public space. And I think just to do a few more points, and please give me a signal if I'm out of time. I'm really concerned that obviously all of these things do not apply everywhere and not all the time. There's good years, bad years in every country. Sometimes the judiciary is very receptive to our cases, and we need to seize those opportunities. And then there will be a regression, and then a new judges come and they are more conservative, and this is ebbs and flows all the time, particularly in the global south. But I do fear that the availability of certain technologies, particularly surveillance technologies, identity systems, and mass surveillance in general technologies, are giving rise to authoritarianism around the world, or to bring authoritarianism to where it wasn't, or to make authoritarian countries even more effective in being authoritarian. And I think a couple issues that I will raise that we're particularly concerned and that we believe are really important to get international bodies involved are these two that I mentioned: identity systems and mass surveillance technologies that are connected. Many times these identity systems that are being pushed throughout the global south feed the mass surveillance machines and the mass surveillance apparatus that states build. And we've had in Mexico and Latin America some good some interesting jurisprudence that I think I totally agree with the point that was made before about sharing good outcomes and making sure that we're looking at each other with the good outcomes, not necessarily the bad ones. And for example, we had a good case about overturning a SIM card registration law that was supposed to force every cell phone user in Mexico to give biometric data to be able to buy or use a cell phone, a SIM card. And we were able to overturn that law, and we're still waiting for the full judgment so we can make use of the things that are there, to use it in other places, to share with other countries. And I think it's really important to build this South-South, this Africa, Latin America, Asia collaborations, because there's also another issue that we face as people doing litigation on digital rights in places like Latin America and Africa, which is the judicial and legal colonialism that we suffer, for good and for bad, in the sense that sometimes we use European jurisprudence, like, hey, European did a good judgment, let's use it, and our courts, which are still have a colonial mentality in many ways, they give a lot of credibility to a judgment that comes from Europe and not necessarily a judgment that comes from other parts of the world. And we will be fools if we don't use that in our favor. But also we have to recognize that that also proposes limits, and the fact that many of these issues are being solved in countries, in places very different to ours, don't take into account the complexities of the context of our places, of our countries. When you analyze an issue about surveillance in a very established democracy with very strong institutions, and it's different from a place like where I live, where organized crime, drug trafficking gangs are in bed with the government all of the time. And when it's not the same discussion about giving the intelligence agency of Mexico access to a very powerful surveillance tool, when there's a lot of evidence that those agencies have often been colluded with organized crime, that if in Denmark or Sweden or wherever, we're discussing these limits and these checks and balances, and there's a functioning parliament and a functioning judiciary, it's different. And sometimes just bringing jurisprudence or issues as they are resolved in those places, they lose the nuances and the risks and the harms that are being done in our countries. So the last point that I want to make is also very concordant with things that have been said before. Advocacy is key. We need to understand that judges are part of society, and there's many ways to influence them, not only through our briefs and through the papers that we present to them, but also that there's a general awareness in society where those judges are part of, about the harms, about the issues, about the problems. And so that's why it's very important to not only rely on the strength of your arguments and your brief, but to really be part and collaborate with other organizations, with journalists, to sensitize journalists, to sensitize judges to these issues, to make them understand why there are a problem, to make space or make the field more ripe for our cases. So I would leave it at this, and hopefully we can continue to discuss on the Q&A. Thank you very much.
Thank you so much, Luis. Thanks for that intervention. It was great to identify issues that were raised by our earlier speakers, happening in Uganda, that you are also litigating in Mexico. And I think that naturally shows that the challenges are similar. And so we could really benefit from deeper collaboration, South-South collaboration, as you called it, in preparing litigation, but in also using positive jurisprudence and, learning from successes and even maybe cases that were not fully successes at the instance, in replicating or using those as reflections as we carry on strategic litigation in Africa and for colleagues in Latin America too. I love the piecemeal approach that you propose, because I think there's always the tendency, to go the whole haul and throw everything in and hope that at least you get something out. And I think there's a conversation to be had there in terms of what the ideal approach is, because it may be that it's not a one-size-fits-all situation. It may be that for certain courts that have shown interest in dealing with these sorts of issues, maybe you can throw in everything in your case. But for other courts that we have noticed some reluctance in addressing some of these issues, maybe then that piecemeal approach is the way to go. But the question is, who studies these courts, which I think is an issue. It is a recommendation that is also coming out from this conversation. We need to spend time understanding the psyche of the courts, the judges, to know how we relate with them in terms of advancing digital rights in particular, but even human rights broadly. So thank you so much for all those comments. And yeah, we will be back with questions in a bit. Thanks again. Our next and our final speaker today is Sofia Jaramillo. Sofia Jaramillo is my colleague and has had extensive experience working on digital rights issues for a long time, and would bring some of that of her experience to the conversation we'll have today. As with others, we will share her full bio in the chat. Thank you so much for joining, Sofia. The floor is yours.
Thank you, Kechuku, and thank you to my previous panelists. It's always always tough to be the last and to follow such insightful comments and this outstanding group of people. I will build a little bit on some of the comments that have already been made, and I might repeat a little bit. Like, I will echo Dorothy's point on collaboration, typically points on just litigation being part of a broader process that's in a way it's a similar way of what Luis Fernando was saying, of the building blocks of doing strategic litigation. At Robert F. Kennedy Human Rights, we've supported advocates and litigants in their efforts of bringing justice in different parts of the world, in Latin America, in Africa, and some parts of Asia. We've done it by just filing amicus briefs, supporting specific cases, litigating ourselves in other types of cases. But we are about to launch also it's a new project that we're about to launch. We will shortly launch the Civic Space Case Tracker. It's going to track ongoing litigation related to civic space. Obviously, it's going to include a lot of the digital rights cases. And I think it goes a little bit to the point that Luis Fernando was making on, like, we need to further the collaboration, find innovative ways to just make it easier for others that are doing this type of litigation to access translations, to accessing already filed amicus briefs, and to also know who is litigating similar cases. There's a lot of different databases that talk about cases that are already resolved, This one is going to be about ongoing cases. So I think it's going to further, we hope that it furthers collaboration with the ongoing litigation. Just a little bit of promotional. But so we've talked about Africa, we've talked about Latin America, we've talked about the challenges in both regions. I want to talk about the UN and the UN treaty bodies. The UN has a plethora of mechanisms. We have the special procedures, we have the Human Rights Council, we have the political bodies, but the UN treaty bodies, this group of people that are in charge of interpreting the core human rights treaties, that we have 10, 9 of them have individual complaint mechanisms. I think they are also a big tool for digital rights. I might focus my conversation on what might come next. On digital rights, they haven't said anything specific, like they haven't had a lot of jurisprudence, and that is, they've only issued one decision. If later on in the next couple of hours, there's going to be another panel specifically about UN treaty body litigation. One of the co-sponsors of this panel, the University of California in Irvine, the International Justice Clinic, that is led by a former UN Special Rapporteur on freedom of expression. Sorry about all the words. They have a project specifically about like tracking what UN treaty bodies have done on digital rights. And I will highlight that because it's like they've only issued, from the 9 treaty bodies that have the power of so just issuing judgments or individual communications, there's only one case about digital rights, related to digital rights. It's in Mauritius, and it's about the handling of personal data by Mauritius, right? So there is a big opportunity on what to do with digital rights before UN treaty bodies. So that's about the state storage of personal information. There is also, as part of that project, what we did when I worked there, we tracked all of the other mechanisms that the treaty body use. So they issue general comments, they do periodic reviews of all the states. So and they do a lot of different other things that can give you a little bit of sense of where their interests are, right? Like they don't have cases yet. They might have it as part of their backlog, but they haven't issued any decisions. So you have to track the other ways in which they, the other mechanisms that they have at hand. So with that, for example, it's very, very common for people working in this field to know about the General Comment number 34 from the Human Rights Committee, the committee that interprets the International Covenant of Civil and Political Rights. That general comment basically distills what the right to freedom of expression is, gives it a little bit of more, like it interprets its meaning. So we can use those mechanisms to know what their interests, what are the interests, but also you can use later on, since it's the UN, when we are litigating in regional systems, we can use whatever comes out from treaty bodies to help the courts interpret the regional instruments, right? So we can use it in different ways. So it's about just litigation, whatever the forum you choose, just use it, using that litigation as part of a whole other process. So maybe I'll just mention the 5 areas that are identified, that are prone, that are ripe for litigation on digital rights. I'll mention it so we can spark the conversation about the future of litigation afterwards. These are the 5 main areas where we found, by just analyzing all of these communications, where we found that there might be an opportunity for litigation. So we have state storage of personal information. We have social media monitoring, both in both sense, over monitoring and under monitoring social media by states. Over monitoring by, again, Human Rights Committee has been focused more on like censorship and this taking down of content that's legitimate, that might not pass the 3-part test of legality, legitimacy, and proportionality. but also you have CEDAW and CERD that might be more interested in under monitoring hate speech or discourse or expression that might incite violence. So you have that type of possibilities of litigating there. You have a lot of interest of doing website, just litigation and website blocking and internet shutdowns that we already have in Africa, big outstanding decisions related to internet shutdowns. But at the UN Treaty Body, we haven't had that. We have a lot of different decisions, a lot of different comments from special procedures, from the Human Rights Council, from OECD, from the Office of the High Commissioner of Human Rights, just stating the standards that should be applied for this, but we don't have at the treaty body level decisions about this. There's a lot of communications, a lot of general comments related to also to the surveillance of journalists and the surveillance of human rights defenders. So that's another area, big area, where there could be litigation. And the last one would be barriers to internet access. Again, there's another panel, one of co-sponsors will go deeper into treaty bodies, but I just wanted to mention that part. Oh, Ikechukwu popped out, so I might be running out of time. I was going to say that similar to what happens at a regional level, both in Latin America and in Africa and sub-regional and the regional systems, there are a lot of challenges, time being one of it. So it takes a long time for them to decide. The same at the UN level. And if we understand that litigation, as Sobekile was mentioning, that this is just part of the process, that the submission that we present before a treaty body, for example, or the complaint, however you want to put it, like if we can use that as a piece of advocacy, if we can use later on, even the litigation, even if it's not successful, this was also something Sobekile mentioned, that like you can do winning by losing, even if you don't get a favorable decision, you can use that for something else. You can use, if you're working in collaboration, as Dorothy was mentioned, if you're working with a network of advocates, of journalists, of other civil society organizations, you're not doing this alone, you're doing it strategically. Even just starting a litigation before a UN treaty body and using it as a starting point, that can be very useful. The other part that I wanted to mention, I might not, just before I get too good, that it's timing me. Like we've seen so far at the UN treaty body, like you have a lot of soft law developments related to digital rights. We want to have usually how you create, for example, general comments, how you start a general comment, and you saw it, if you see the general comment 34, is based and full of citations to cases decided by the Human Rights Committee. When they were trying, it's just an anecdote, when they were within the discussions of General Comment 37, that's about the right to assembly, they didn't have any cases within the UN system to base the general comment. They didn't ground it specifically on cases, and that's why it took a long time to issue that general comment. So by bringing those cases to the treaty bodies, we can have these other elements that could be used, like not necessarily a specific case before a UN treaty body, but later on, if we further the interpretation by these bodies, the interpretation that they're doing about specific provisions, and use it, whether it's in the inter-American system or in one of the African systems. If we use that, we can further that jurisprudence. Like we can start building the different blocks by litigating at the UN level, bringing it down to the regional level, or the other way around, like bringing the jurisprudence from different regions to the treaty body to further their interpretation. I'm receiving some messages, so I imagine Ikechukwu, I don't know, I cannot see all the other messages. So I'll stop there. There are so many other things that we can talk about. I don't want to predict the future of where litigation might go at the UN treaty level, but these 5 areas that I just mentioned might be prone to litigation. That might be like, if we saw those developments within the other mechanisms that are not individual communications, that gives a hint of where litigation might be going over there. I'll stop it so we can have at least 20 minutes of discussion.
Yeah. Thank you so much. Thank you. And thank you also for mentioning the upcoming session that would focus on treaty bodies. That it would start at 4:15 Lusaka time. And you can get the information on the WUVA platform. Well, thank you so much, Sophia, for sharing that very insightful analysis of what the trends are and where things seem to be going. I love the fact that you mentioned, the issue of, some of these restrictions not passing the 3-part test. And, it makes me think about the fact that some of the decisions that we have seen also, most of the courts have been a bit reluctant in going far enough to analyze some of these threats to digital rights through the 3 prongs of the 3-part test. We've seen a lot of analysis around the legality prong, but we've not seen a lot around necessity, around proportionality, and around legitimacy. And so that I think is something to highlight for future litigation around some of these issues, especially where it pertains to freedom of expression. But at this point, so thank you so much, Sophia, but I think that's a good segue to the Q&A section and the conversation with the panelists, who I would invite to all come on board now for us to have this conversation. And I'd again to thank you all for these fantastic presentations, and to encourage others, if you've not sent your questions, please feel free to send them in. And I'd like to start with some of the thoughts that came out, a reflection around the intention of strategic litigation, sometimes, especially before domestic courts, to get the courts to reflect on the constitutionality of these steps, or the constitutionality, for example, of an order from the executive to turn off the internet, or the constitutionality of a law passed by the legislature. And we found that in some cases, as Tobekile reflected on the Zimbabwe case, where the decision came, but it was on the process of the decision and whether or not the government official who ordered the shutdown was the ideal person. And so it seems to be, that there exists that desire to further jurisprudence and to get the courts to engage on the meat, the legality of these issues. But sometimes we see that some of the decisions don't go that far, just stop at the level of some of these procedural issues. And in some cases, as we saw in Zambia, there are even consent judgments where the state institution makes a promise to refrain from certain steps in the future and to inform people before the internet is shut down. And so I'd like to know, and please feel free to take a side, where do you stand, like in terms of going into strategic litigation? What would be your desired goal, in the face of either getting, jurisprudence, or solving the harm that is ongoing? What would be the goal, and is there a midpoint? Anyone can take it. Yes, Tobekile.
Okay, my end goal definitely is to revolutionize the law in my country and how it is implemented, right? So I would love to see a situation where digital rights are protected. It's like natural for the judiciary to be inclined towards that. So right now, I think Sophia was talking about the three-part test, and I don't see that test even be mentioned in most of our laws. In fact, it's a digital rights test, so to speak, because that's where we really realize that we have to interrogate aspects of legitimacy, and necessity, proportionality, things like that. But the three-part test, to be honest, looking at how the judiciary affects, judgments, they don't really, talk about it. So I would like to revolutionize the law in my country and to see application that has lasting results for digital rights.
Okay, so if I hear you clearly, yes, of course, to solve the existing challenge, but even beyond that, structural change, policy change, attitudinal disposition of people in government, and to pass policy and laws that protect digital rights in a wholesome manner. And so for you, give me all of it. You take all of it.
Yeah. 360 degrees shift in how things are happening, total overhaul. Because at some point we have to come to a place where we accept that we're in the digital age, and there's no need for the police, the government to have such paranoia around the digital age and the internet and what people do on social media, for instance. It's, in fact, across the whole continent, there's need for a paradigm shift within judicial systems where we are more inclined towards digital rights. But now, as we speak, trust me, the capacity is lacking within the judiciary, and for them to be able to appreciate that there's this, we are evolving, and this is the direction we are going, and the future is digital, and this is the space where we are in already. And definitely 360-degree shift in terms of attitudes from the judiciary, all government institutions, be it the Ministry of Health, and addressing health surveillance issues, across the education sector, promoting digital inclusion and overhaul in all these areas. We need to be able to litigate on cases that change the face of the law and how it is implemented across all these sectors. And it starts with strategic litigation, and that's really my drive.
Right. Thank you so much. I'd like to bring you in here, Dorothy, just to reflect on the digital ID conversation and how it's playing out in Uganda, and what you think. I know there are some pending cases, but what you think the future holds, in addition to for example, an outcome that is positive, or one that's not positive. What should litigators in Uganda be thinking about in terms of digital ID? And I would also like Luis to come in after that, because you've litigated cases around digital ID. What lessons have you learned, and what do you think also you may borrow from what Dorothy would talk about in terms of what they are doing in Uganda?
Thank you. I think my microphone. So I think whether positive or of already the case that you have before the courts on digital ID, I think already public awareness is being created. Yeah, even before the court hearing comes ahead. We'll have the first court hearing in next month on 3rd. So even before we have the court hearing, already public awareness, because this is already an issue that's affecting millions of Ugandans. Millions of Ugandans today do not have an ID, and many of them are bounced from either accessing employment, access, even mere access public passport, communication, SIM card, to be able to international. So, the errors that are really made the enrollment officers.
I'm so sorry. I'm so sorry, Dorothy. We can't hear you clearly, and would really love to get the point you're making. So I don't know if you can just step back a bit and just go back to what you are saying, maybe like 10 seconds ago, so that we can follow up.
Okay, am I back? Can you hear me?
Yes.
Good. As I was saying, I think a public awareness has already been created because before it's an issue that many people are affected, but nobody was about it. You know, people bounce from accessing a SIM card, accessing public buildings, accessing passport, you know, being able to be enrolled in public service. All these are effects of one failing to be enrolled into the system. But most of the time, it's about people failing, you know, or using rejecting, but whether the system rejecting, you know, the process is really very slow. So the biometric, yes, especially the old ones of whose thumbprint is now because of so the system rejects them, and the case has brought about the publicly. You know, Africa, parts of the world, is common system is introduced under the guise of protecting national security, and therefore this is a subject that public conversations, you know, public are supposed to speak about, and for us coming out and challenging a system that is really has that connotation is a plus for the communities. You know, they see they've come out their concerns about the system. So because what we're asking and telling government to really ban the system, but we are telling government, look, there are flaws in the system. People are being bounced. There are so many challenges when it comes to environment. And these are facts that government itself knows. Parliament has debated this, and government has presented ministerial statements before the floor of Parliament and highlighting, eliminating all these challenges. And also enrollment, I mean, the agency that is responsible for enrollment of this system of the ID is aware of all these challenges. So we are telling government, you know these challenges, right? But again, you're making a very pragmatic system to be mandatory for citizens who are already excluded, you know, from accessing public services. We are telling government, please hold the system or allow alternative means of identification for people to be able to access, to be identified and access public service. Okay? Because originally there's IDs that have been used, authentically issued by the government. You know, can we again continue with such identifications for people who are already vulnerable to be able to access and be included? Because at the end of the day, the system was introduced under the guise of including people, but it's actually downplaying the intention of inclusion. People are being excluded instead. And this is where we are coming from. So for us, we are optimistic that we are win in terms of ensuring that alternatives are really accepted, because at the end of the day, we are very strategic. We had a very debate on whether we need to ask the courts to ban the system, which we think we can't achieve. But then can we have alternatives if we present all this evidence of millions of Ugandans that are being excluded from government services, you know?
Right. Yeah, no, thank you so much for those thoughts. Really goes to the point of, you know, approaching the digital ID conversation in a sense through the lens, through like a human rights lens. So highlighting the potential for discrimination, for excluding vulnerable communities from accessing government services, and also, you know, that's thoughtful relief around alternatives, and not, you know, not just asking for a blanket ban, but also asking for alternatives. Those are really very thoughtful approaches. And, you know, I'm just waiting to hear what Louis's reflections are and how they've also litigated digital ID issues in Mexico.
Yeah, I agree with many of the points that have been made. I think for us, it was really important to be able to be prepared to challenge the narratives and the stories that governments push. In our case, that are very simplistic. No, it's nothing new. It's there's insecurity, there's crime, and we need to collect everyone's biometric data to solve it. No? We've invested a lot of time in trying to make that argument less compelling, although it remains to be compelling for some people. And one of the main ways, and this is maybe doesn't apply everywhere, but it does apply here in Mexico, which is the distrust that we all have with regard to the police and to the army and to the government, because so often, and we need to make those arguments and to make people relate to the arguments that we're making as well, in the sense that every day or every couple of days we see news that the police were doing kidnappings, that the army was killing people, that there are disappearances. So this very simplistic way in which governments push for these types of systems, in which they say they paint a problem and they say this is the solution, we need to be able to take apart all of the arguments that they make. And we were very successful in doing that, in showing and gathering evidence and showing evidence about how similar systems here in Mexico that were tried in the past or in other places of the world didn't work to reduce crime, that they were easy to be eluded and circumvented by criminals. And you do the public debate and you do the work of challenging politically and with evidence these challenges. And there's one thing of the outcome that we're very interested in, and I think something that we need to also point towards more in our litigation, I think globally, which is obviously we want to win, and we won in this case, no, on the merits and on the meat of the question on whether it's proportionate to force everyone to give your biometric data to have a cell phone. The court said it's not proportionate, it's too much. You haven't, and there's a onus probandi, the state needs to prove that there's no other way, showing that there are alternatives, because we cannot, I agree, we cannot only say like this is disproportionate, but yes, it is disproportionate, but also you have other ways. It's not like you don't have any way to combat crime if you don't have the biometric data of everyone. You have other ways in which you can do investigations and you can combat crime. And we need to be sensitive about those things. I totally agree. We need to also give proposals about alternatives, all of that. But one of the things that we're very interested and excited, I think something that we want to do more is we're still waiting for the judgment, but it appears that it will also say that before Parliament or Congress to pass legislation that affects privacy rights, they need to do a privacy impact assessment, no? Which would help us in many ways and help the courts in many ways, because then you are not litigating, which is a problem of digital rights litigation, because many times litigating on hypothetics, on things that might happen, things that are risks. And it's more difficult to find individual cases about things that already exist. And then even if you find the cases after something already exists and it's producing harms, it's much more difficult to revert a system that is already working, particularly identity systems, which, I mean, it would be an administrative nightmare to backtrack all those systems. So it's more difficult to take something down once it's been for years working in some way than fighting it for it not to be approved or not to be implemented, which was the case. Even though the law was passed, there was a 2-year period in which it was going to be implemented, and we were able to challenge it. So I think if we cannot win, well, let's try to win. But if we cannot win, also win things that help us do more litigation. Right. That these things that was mentioned about the internet shutdowns, like, okay, you need to let people know that you're going to do an internet shutdown, and that creates opportunities for more litigation. So we should focus on these intermediate questions that help us get better cases and better positions to challenge these types of things.
Right. Thank you so much, Luis Fernando. I'll just pass to Sophia on this digital ID issue. Yeah, do you have thoughts?
Yeah, sure. Like there are so many. I agree with everything both Dorothy and Fernando are saying that, and like, yes, we understand that the systems sometimes are implemented. We need to ask them the questions, the specific questions, like why are you doing this? Are there alternatives? Maybe propose it, but like we're not saying, and this happens with a lot of digital rights litigation, that we're not against the tech. We're not against including new technologies. We are just making sure that the processes that there are not tools for exclusion, that the processes that they implement in order to implement these technologies are in accordance with human rights. There is a big campaign, I think it's led by Marianne Diaz from Access Now, on the digital ID and like why ID, or this digital ID proposal from the World Bank. And they highlight, for example, some specific things that can be applied to any process. If we take any process that wants to implement like digital IDs, like you have to invite and fund independent right-based assessments in supporting the systems, right? Like you have to assess the existing evidence and the existing evidence on the possible human rights risk that these programs can have. You have to enforce, like you have to make sure that the governments enforce a greater transparency about everything that they're doing. Like we can do, like Liz was saying, like there are a lot of intermediate steps that we can take. Like we can make sure that the process is okay, that what they're doing is transparent, that they're consulting with civil society. Like these are human rights-based approach. Like we can take the principles, like business and human rights principles, and apply it to a lot of the processes that are happening in different countries. So like we need to just create opportunities for sustained and like high level involvement of civil society in these initiatives. Like this is like a general comment afterwards. And I think we are out of time. So
yes, we are.
I'll leave it there.
Yes, I would have loved for us to, continue on this conversation, because it's really helpful in the context of thinking about future litigation. But this is the much we can do now. But I'd really like to thank our panelists for taking out their time to be here, and to thank you for your insightful presentations and your valuable comments. We would follow up on these. One key outcome of this conversation is to publish a white paper that would contribute to the thinking around strategic litigation going forward around these issues. So we'll be in touch when we have drafts for your inputs, and to build on some of these comments of your interventions during the panel. And of course, we'd like to thank our attendees for your participation, for being here, and would like you to continue to engage with us on these issues. And you can always check us out at rfkhumanrights.org, and DM us on all social media platforms. I'll be happy to engage with you on this issue. I would like to thank everyone for a fantastic panel. I'd like to thank CPESA for hosting and organizing this event. I see from the WUVA platform that our panel was really doing well in terms of participation. So I'd like to really thank you all for being here today. And I'll close it up with just a call for us to continue doing what we are doing. The pressure from repressive governments may be heavy, but we are strong enough together to hold the fort and to push towards progressive jurisprudence around digital rights and human rights broadly. So thank you so much for being here. Until next time, stay well.
Thank you, everyone.
Thank you.
Thank you. Thanks a lot.